let's share our knowledge. Let's share our talent, because without each other, it's a lonely road.
Well, I couldn't agree more. You know, I remember when I had the pleasure of first coming into contact and making your acquaintance, you and Dr. Klaus a few years ago, and you know, Dr. Klaus, your partner, continued to talk to me about quiet title, and at the time, I was experiencing some issues with my mortgage lender. I was also helping clients and picking up properties subject to and helping people from the trustee side of it. And no one had a clue what quiet title is. I didn't know what I was doing. A lot of the attorneys didn't know, but I still just followed your advice. And it's just amazing to see where you've gone with this knowledge and the fact that now you're doing trainings and teaching attorneys around the country about this stuff. And it's really relatively new, I guess, even from a legal perspective, or at least with foreclosures. So I don't know if you want to maybe, as we just start off slowly getting into it while a few more people join, I don't know if you want to jump in a little bit and talk about how you got into quiet title.
Right. Here's what we'll do, okay? Because I welcome this opportunity to chat with everybody, and thank you for taking time out of your evening and giving the old man your ear. Here's really what has transpired. You know, if you look back when you bought a home, you went to the bank and you filled out some paperwork. And one of the pieces of paper that you signed was your mortgage. And it was notarized and it was recorded with the Register of Deeds, or clerk of county, clerk of court, whatever. Okay? And the other piece of paper that you filled out and signed was a promise, and let's say you borrowed $400,000. Well, you signed a piece of paper where you promised to pay that man across the table or his representative $400,000 over a period of 30 years or 20 years or whatever the term was. But you signed that piece of paper and it was not notarized. But it was like signing a blank check. But it was a promise to pay, which made it a negotiable instrument. Now, when you signed that paper, you thought that the bank was going to give you $400,000. That's what you thought. Well, when you signed that piece of paper, what did they give you? They didn't give you anything yet. You just signed the document, and that piece of paper became an asset for that bank. It was now an asset that they owned. You no longer owned it. Yours was a promise to pay. So that asset was now $400,000 of theirs, and here's what they did with it. They didn't give you any money yet, but they took that asset and they created a bond, just like you would bail your nephew out of jail. They created a bond, and that bond they took it to the Federal Reserve, and the Federal Reserve gave them approximately 10 times the amount of your promise to pay. Now, let's say your promise to pay was $400,000. The Federal Reserve gave them a credit of about $4 million. Now, how much money have they put up? They have put up absolutely zero. They leveraged, and the technical word for it is monetized, but they leveraged your promise to pay to create $4 million. And they still had your promise to pay. They kept it. They just created a bond. They then took your promise to pay to another party, and we'll call that party a wholesaler. And that wholesaler took it to what we call an aggregator or trustee. And it was then sold to a trust. And 95% of the trusts are in New York. So it was sold on Wall Street. Well, where did the money come from for this note? Where did it come from? Well, the trust filed, before you even applied for that note, the trust filed what we call an 8K filing with the Securities and Exchange Commission, and we'll call it the Rosado Trust. And they told the Securities and Exchange Commission that they were going to sell investment certificates, and they were what we call mortgage-backed securities, or they were called CDOs, collateralized debt obligations, whatever fancy term they called it. That note was the security for these folks to induce certificate holders or investors. Let's just say the folks that are listening to this phone call. Let's say they represent the school teachers in their area. So the school teachers' pension plan invested $10 million each into this trust that was backed by your promise to pay. So they were given, let's say 6% return on their investment. But you were paying maybe 7%. So the trust was earning money. Okay? Now, those certificates, okay, that were purchased by the investors, okay, that money went back to the bank that you signed that promise to pay with, and that's where the funds came from for you to buy your house. Wow. Wow. Listen to this for a minute. That piece of paper that was never notarized traveled all around the world, gathering a lot of money. It created $4 million for the bank in credit on your signature. It also induced a lot of school teachers' pension plans or firefighters' pension plans to invest into that trust. They got an investment certificate, and the funds came backwards to the bank, and the bank then, through the title company, they provided the $400,000 to purchase the house. Good deal. Very good deal. For who? For the bank. They got $4 million in credit and didn't put up a nickel. Now, the trustee for this trust, he is provided what we call a pooling and services agreement. That's his management book. That's his rules. That's what he has to follow to comply with the SEC rules. So in that pooling and services agreement, there's a clause in there that says if you fail to pay your mortgage, they entered into an insurance contract so that if that mortgage wasn't paid, the insurance company would pay it. But the money wouldn't go to you. It would go to the trust. So then we call that a credit default swap, and the insurance company is, listen to this, AIG. Now, when you got in trouble, and, you lost your job or your overtime, or for whatever reason, you tried to contact the bank and you got the runaround. You ended up talking to this person, that person, submit these papers. Oh, we lost them, submit them again, and all that crap that goes with it. But you were told we can't help you until you're 90 days late. Everybody's heard that. Well, guess what happened on day 91? On day 91, the insurance policy that the trustee entered into with AIG triggered a payoff, and the trust received the full amount of the note, regardless of how much you've paid on your mortgage. they got the full amount of the note. So if the note was insured for $400,000, the trust got $400,000. But here's a mystery here, and I'll explain it as easy as I can. The Federal Reserve allowed the trust to leverage that $400,000 note 30 times. So they created 30 different levels. Now your $400,000 note is purchased by other lenders, and along we go. So let's go back to the default. The AIG paid off the note when it was 91 days late. So at this point, who has lost any money? Nobody except AIG or insurers like that. Smith, Solomon, Barney Brothers, and all that stuff. Now, someone attempts to foreclose. And let's say the lender that you got the note from, they're going to foreclose on you. Or the trust is going to foreclose on you. Or let's say it's Wells Fargo acting as trustee for Bear Stearns Trust. Well, they're trying to steal the house because nobody has any skin in the game. They've all been paid commissions, and they've been very successful in stealing houses. What happened here? Well, I sat in the Fort Myers courtroom many times, and I watched average folks, lose their house in 5 minutes because they didn't have an idea of what to do, didn't know where to go for an answer, and didn't have any money. Now, in this foreclosure arena, so I'll call it a football field, in this field of litigation, the only players are the consumers who have enough money to pay an attorney. And what is he doing? He's delaying the time so that you maybe save a couple of months of rent or mortgage payments. But at the end of the day, when you pull the shade down, turn the lights out, he wins a dismissal without prejudice, which means the bank that is foreclosing, who doesn't have any skin in the game, will come back again in a month and try to foreclose again. So what is quiet title? Here's what I did. I said, okay, when you're in trouble, you're trying to find some person to talk to, someone to give you straight answers. And what do? They stonewall you. They firewall you. You can't talk to this person, that person, and all that crap. So a quiet title action, which has nothing to do with your debt. Nothing to do with your debt. A quiet title action means this. Your Honor, I cannot sell my house because the chain of title has been broken. And why was it broken? It was broken when you closed on the mortgage and MERS was involved. MERS took possession of the of the mortgage electronically, and the bank sold the note. Now, how are we doing so far, Randy?
Fantastic, Reach.
Huh?
I think fantastic.
Okay, all right. I'll keep going.
Actually, what I'll do is, I'll give a couple of pieces of information because I know some people may have some questions.
Okay.
So what you can do is if you've got questions and you have the ability to text or email, you can text the questions into 561-444-9179, 561-444-9179, or you could email them to Quiet Title. It's quiet-title@rosatocompanies.com. That's plural, ROSADO companies, plural.com, and I'll get them out to Regis for you. In the meantime, Regis, go ahead.
Okay, I'm glad you took that little break because I took a little sip of my Merlot wine. All right.
Anytime you feel the need, let me know.
All right, I'm ready to go. Right. Well, the mortgage when you closed on the loan and if MERS was involved, the mortgage became separated from the note, and you can't. Once the mortgage and the note are separated, the chain of title is broken. Chain of title.
And can you spend a minute talking, because right now, you know, anyone that's in the industry sees what's going on with MERS and everything's coming down, but I know there's a lot of people that doesn't understand the significance. Can you spend just a moment talking about MERS and why that's such an important role for quiet title?
Right. MERS technically is Mortgage Electronic Registration Systems. They were formed by the banks, and the banks became members. And MERS, at the closing table, is named as the nominee lender. They take possession of the mortgage electronically, not the hard copy, but electronically. MERS, their theory is and was that by they being the nominee lender and having possession of the mortgage electronically, they believe that the note followed the mortgage. And there are some judges who don't understand this who agreed with that. However, the U.S. Supreme Court in 1872 said if the note and the mortgage are separated because one secures the other, if they're separated, they're both null and void. And to simplify it, if you were going to buy my car, you're not going to give me the check until I give you the title. The keys to the car are one thing, but the title is another thing. Now, MERS took possession of the mortgage, but they could not take possession of the note because the Kansas Supreme Court ruled that they are not a lender. With that being said, your loan was bifurcated. That's a legal word. Bifurcated right at the closing, but you didn't know that. Now, that means your chain of title was broken. So, fast forwarding ahead, we simply said, and this workbook that I created, and I'm the only layman that I know of, and I've been told this, that's ever been approved by the Florida Bar to teach attorneys about this subject. I've subsequently been approved by the Georgia Bar, the Wisconsin Bar, the Nevada Bar, and other states to follow. So that's quite an accomplishment for a little white-haired old man to be able to be certified to teach attorneys. So now, when we have the basis for a quiet title action, we simply say to the court, Your Honor, the chain of title is broken. I cannot sell my house. And I'll give you an example of how important the chain of title is. I bought a home that Dr. Klaus, my business partner, found for me. And at the closing table, the closing clerk, girl I knew, she'd been closing for 33 years. I said to her, Audrey, I just signed a very, very important document that's worth a lot of money. I need a receipt for my signature. When you do a transaction with a credit card, don't you get a receipt? Absolutely. When you spend money, don't you get a receipt? Absolutely. I was just spending a lot of money and I asked for a receipt, and she said, we can't do that. What they gave me for a receipt was a special warranty deed. That means the bank who said they owned the home was guaranteeing me a clean title only from the time that they owned the home until the time I bought it. Well, here in Cape Coral, we recently had, or not recently, back in July, a headline story where an attorney and a real estate broker paid a bank $158,000 cash, and the bank did not own the home, and the attorney accepted a special warranty deed. Well, today, if you're buying an REO or a foreclosure home, I can solid guarantee you, you cannot get title insurance. So with that being said, the quiet title action flushes out anybody who has a recorded legal interest in the title, not the note. The note has nothing to do with the quiet title action. And in a lot of cases, no one shows up. We have one here in Cape Coral. Fannie Mae didn't show up because they didn't have a recorded interest. The mortgage and the note were never assigned to them. Now, with that being said, I know it sounds convoluted, but what's the meat and potatoes of tonight's call? The meat and potatoes of tonight's call is, in order to file a quiet title action, you cannot go into court with hearsay evidence. You cannot say to the judge, Your Honor, I found this out, or my friend told me this, or I think this. You get laughed at and thrown out, okay? What you need is a securitization audit which follows the paper trail from the time you closed until it enters into the trust, and a Bloomberg financial report that pulls out all of the financial information about the trust. When you have that information and it's accompanied with an affidavit sworn under the penalty of perjury, you now have evidence, you now have admissible evidence to the court that the note was paid off when the insurance or credit default swap was triggered. Well, if the note was paid off, who is damaged? Who is damaged? Nobody. The only logical people with a claim to that house, only logical people, would be the insurance company that paid out the claim. But now, here's the end of my story tonight, and then I'll open it up for questions. If you have your vehicle insured by, let's say, Geico, and you total it, Geico will write you a check for the value of the vehicle, but who owns the salvage rights? Now, think about that for a minute. Write your question down. Think about it. The salvage rights are owned by Geico. They then part it out or salvage, sell it, whatever, so they can minimize their losses. Well, in the foreclosure arena, the insurance company is Geico, and if they paid off the certificate holders, then they would have a claim to the house. Logical. Except they insured unsecured notes. Remember, at the closing table, MERS became the nominee lender. It separated the note from the mortgage. The U.S. Supreme Court says that they're separated. They're both null and void. Well, Geico insured unsecured notes because the notes that were not accompanied by the mortgage or vice versa. Therefore, they had no claim on the wreck or the house. Whew. Now.
So essentially they're double dipping or more. They're double dipping and triple dipping even.
Absolutely. And today, Geico has a big-time lawsuit against Bank of America because Geico, I'm not Geico, my God. When you get my age, you can invent words. AIG has a major lawsuit against Bank of America because Bank of America defrauded them on the quality of the loans. The loans were rated AAA by Standard & Poor's or Moody's or whatever, when in fact they slid into that pile of loans. They slid in some toxic loans, some marginal loans, and Geico ended up paying based on misrepresentation. Wow, what a hornet's nest. So, for those folks who are interested in taking a step further and learning more, I would suggest this. Randy, I think you've got an event, a workshop, or something scheduled there in West Palm Beach. Yes, anybody who is an investor, even a homeowner who has concerns, or an attorney, I would highly recommend that they attend your event. In fact, I think I'm scheduled to speak at it. I would highly recommend that they attend it because there's so much information to learn. Now, I want to add this. Today, I had a call from the CEO of a legal group that represents, or these attorneys are members from all over the country. And they want me to make a commitment to teach this legal group all about quiet title because, and here is the nuts and bolts of it. Everybody that has an attorney, they take all of their problems to the attorney, where in the medical field, you don't take a heart problem to a kidney specialist. You don't take a back pain to a foot doctor. But in the legal arena, people assume that their attorney knows everything. My son is an attorney, and he's dumber than a box of rocks. He only knows one thing: divorces. So when I mentioned quiet titles to Timmy, he said, "Dad, we didn't have that in college. I have to go find out about it." So that's the reason that we're teaching attorneys, so that folks that have an issue or they want the answers, we can direct them to an attorney who understands it. And once an attorney understands it, it's much easier to have the operation done. And you certainly don't want a heart surgeon operating on a blister on your foot. It's a waste of money. So we've identified this. We now have a group of attorneys started. And today I talked to the CEO of a legal group that has attorneys in every state except Hawaii, Alaska, and the cowboy states. And they have, I think, 62 law firms. And they want me to teach all of those law firms all about quiet title, because these boys, they've admitted it. They simply don't know it, but they won't tell it to their clients. You ever have an attorney tell you, "I don't know something"? He said, "Well, let me think about that a little bit, and I'll call a colleague in, and we'll get it done." They never admit defeat. Hell, attorneys, if you ask them their scorecard, they'll say, "Well, I had 500 cases and I won 400 of them." Where are the other 400 losers? All right, I shot my wad. I'm going to take another sip of Merlot here.
All right, well, I'll jump in and make some announcements, Reg. That was awesome. And for everyone out there, just a few announcements. We have a full workshop. It's going to be a full day, 8 a.m. to 6 p.m. on December 10th. And I know December is a tough time, but it's beautiful here in Florida. It's going to be at the Crown Plaza in West Palm Beach. It's an all-day event, breakfast, lunches covered, beverages throughout the day, and just a ton of information from Regis and his colleagues at the U.S. Property Shop. And then I want to announce another date that just came up today in Greensboro, North Carolina. My old friend from 20 plus years ago, my childhood friend who got me my first sales job, Phil Dean, is out there leading the workshop in Greensboro in January. So if December doesn't work for you, we've got January 21st, January 21st at the Comfort Suites. If you need information on that event, you can contact Phil directly. Phil Dean's number is 336-882-6666. And for details on the event in West Palm Beach, you can contact me. I'm Randy Rosado. It's 561-444-9179. And Regis, just some last thoughts. Tell people what exactly they'll take out of this event after they spend all day there. And for the attorneys, I believe it's 7 continuing education credits for the one day.
It's 7 CLE hours.
Okay, so you get
for that one day. Also, Randy, listen, for those folks who are on the call tonight, whether they enroll in the workshop or not, I've got a gift for them just for their interest. Okay, if they take 5 minutes and give you their email address, and you forward that to me, I will give them a free copy of a book that we have on the internet called Getting Out of Credit Prison. It's got tremendous reviews. It's a wonderful book, and I'll give them as my gift for you for them.
Great. And Regis, we do have a question that came in. So let me ask you this question. I'm not going to state the person's name because I'm not sure they want it, but I'm a realtor and investor. I have many properties in various stages of foreclosure, modification, and short sale. Can quiet title action be started at any time during these stages? Are there attorneys in Palm Beaches who can help with this? Who are they? Now, I could kind of answer in terms of the attorneys. I mean, I don't know anybody, but I do have some people from the workshop, so you can contact me. This individual can contact me, and I'll get either that or we'll reply with some information. But we just explain what to do for people like this where they're in different stages of the foreclosure. I know I've been there, so I could speak from personal experience, but obviously you've explained tonight why modifications aren't happening and short sales aren't happening by the bank. So
here's the best analogy. The foreclosure defense is like treading water. You need an attorney, or if you feel competent yourself, pro se, to tread water. That's delay, object, delay, production of documents, whatever it takes to extend the action in a foreclosure lawsuit. Okay, so that you do not have a sale. Now, I'm not saying if there has already been a sale of a foreclosed property, that can also be attacked. But it's much easier if you can delay that game. That's the game of litigation. In the meantime, you get your audits, and this is where Dr. Klaus comes in. Here's what you do, and I did this with Regions Bank. I walked into the bank, and I said to the girl, I want to talk to the president. The bank has dirty diapers, and they really smell. Well, he's in conference. I said, it's no problem. I'll just drop the diapers right here. In less than 30 seconds, he comes out of his office, and he said, I overheard the conversation. What's the problem? I said, you got dirty diapers. There's fraud in these loans. Now, what do you want to do? Do you want to litigate, or you want to negotiate? And so he called his legal department, and I said, here's the proof. You people have already been paid. What do you want to do? And it stopped all the activity in court because you had proof. And that's the value of the securitization audit and the Bloomberg financial report. So if I were a real estate investor, I would not rely on any modification because you're dealing with someone who doesn't own the note. Remember earlier in the conversation, a lawyer here in Cape Coral and the real estate broker. They were partners. They paid the bank $156,000. And Randy, I think you saw the article. And the bank didn't own it. So if I'm an investor, how the hell do I know who owns the note? So the only way I can find out who owns the note so I can sit across the table and cut a deal is to flush them out of the woodwork. And how do you flush them out? You sue them. Wow. This old man's got a lot of enthusiasm. I can tell you that.
Well, that's where I was going to jump in, Regis, because from a personal experience, I'll say in the case, and it was in the Fort Myers courtroom, and I got a late start on that. It was probably approaching final judgment before I came in with the interrogatories and some of the defense from Dr. Klaus, and I was able to get the dismissal without prejudice. So my advice in this situation is, when you're defending the foreclosure, when you're doing the short sale, and that part of it, what happens is you're acting as a defendant. So once that case dismisses, you need to move ahead and file again. Would that be on target, Regis? At least that's how I understood it. And put yourself in the plaintiff position.
And you become the plaintiff.
Exactly. Now we have another question that also came in, and this is they want to know: are you going to get into? You're going to go through how the debt can be tracked through the SEC or service to do such. I'm very interested in your course. That's part of the Bloomberg, right?
That's part of the Bloomberg and the securitization audit.
Yeah. Okay. So, and we actually, if you go to the workshop, because I've been doing this quiet title kind of pro se because I haven't felt comfortable enough with an attorney up until now. Now I've got some good people. But prior to this, I just kind of stumbled into the courtroom, got frustrated, saw people losing their homes begging for an extra 30 days, and it's depressing. And I've been able to, make significant headway in properties in New York and Florida. So it really, and when I went to the workshop, even with that background, the wealth of knowledge I got is really unbelievable where these guys have taken this course. And for the question that just came in, you will actually see a detailed breakdown of the Bloomberg report, of the insurance payouts. All of that stuff will be provided. So that's absolutely what you're going to learn for the securitization.
You will see Dr. Klaus shine. You will see him shine. He's an absolute whiz on this. See, my forte is talking. His is research. And
now, Regis, can I offer another gift? Because
sure.
I don't know if it's only for attendees. Your quiet title handbook. Can I give that to the people who attended the call?
Absolutely.
Or is that just for attendees of the workshop?
No, if you have it and you've got it electronically, absolutely.
Yeah.
Absolutely.
So now Regis is going to give you get out of credit prison. I'd like to give you on Regis's behalf a copy of the Quiet Title Handbook. So go ahead and email quiet-title. Anyone who's emailed us, the two investors that emailed us, we'll shoot it over to you guys. And anyone else, go ahead and shoot us an email, quiet-title@rosatocompanies.com, and we'll make sure we'll get that out to you as well.
It's good stuff. It's something you're not going to buy at Barnes & Noble.
Absolutely. I think that's it for questions, Regis. Do you have anything else before we close out? Oh, we have another question. All right. Everyone's waking up, and I'm going up and downstairs. Okay, here we go. I would like to know who in Miami, Florida does the securitization and how much is it, more or less? Now, I know we get into that in the workshop. Do you have a cost on the securitization service? I have an idea, but I don't want to misspeak.
All right. Here is the cost of the audits. Okay, I believe it's $1,260. That's combined. Now, I can pass this on. You could go online because they sell software to do securitization audits, the same as they did sell software to do forensic audits. However, you can get a securitization audit done by Joe and Janie up in Idaho, okay? What the audit must have is an affidavit with it, a sworn affidavit that becomes admissible evidence in court. Now, they're selling audits on the internet from any place from $800 to $2,000 per audit. We have worked out a deal with the company that we work with because of the volume. We have a large volume of audits, and the total price of the combined audits is $1,260. Now, once the audit has been obtained, now what do you do with it? Well, what Dr. Klaus does, and he charges $500 for his company, and they do a pre-litigation report. In other words, they will identify, not within the audit, but within the paperwork, the assignment, the transfer, recording, whatever, all of the fraud, if there is fraud, and there's fraud in 95% of the deals, okay? They will identify robo-signers. They will identify notaries that have been expired. They will identify so many things. And that pre-litigation report, we're under contract to a number of law firms, and they love it because for an attorney to have this pre-litigation report, he has to tell his paralegal, all right, start looking into this, get this, get that, get this, get that, and I can guarantee you it runs them more than 2 days of research. And he does that for a fee of $500. And so the total would be $1,760.
Okay.
No higher, no lower. That's it. We do not have affiliates. We don't pay out commissions. It's not multi-level marketing. It's the cost of the knowledge.
Absolutely. And Dr. Klaus's research has done wonders for me personally in terms of finding robo-signers and just finding fraudulent assignments. Anything. I mean, it's unbelievable what he's able to find with his team. So just so everyone's clear again, we've got $500 for the research, and again, I could speak for what that's done for me and my own deals, and then the $1,200. Now, I think what everyone needs to understand is that includes the full securitization, the Bloomberg, the affidavit, basically everything ready to actually bring it to the court or hand it to the lawyer.
Everything. They can bring it to the court themselves pro se, or they can take it to an attorney that we have already worked out. Any attorney comes to our workshop, agrees after they've attended the workshop. They can either say yay or nay. But they agree to a flat fee and a percentage on a contingency basis at the end of the deal. So it's a wonderful deal for people, and we do our best to associate them with attorneys that understand what this is all about, versus an attorney that's going to take their money, and there are some out there going to take their money but don't know what they're doing. They apologize and say, I need more money.
Exactly. Well, I think that's hopefully clearing up any questions. Do we have any other questions that have come in at this point? No, I think we're good. So we do. Okay. Good.
Okay.
Another question.
Good.
This question is coming in and saying, you know what, Regis? I was going to ask you this, and this is a great question. He's saying 1760. What's the end game? Property is avoided free and clear, question mark. What is the success rate? I'll jump in quickly and say that I've walked into houses that have been taken free and clear by two of your clients and your friend there, Bernie, in Cape Coral, and I've actually stood in one of his homes, and the homes are adjacent to each other. So I've seen the product, and I've had my own dismissals. But we just explain a little bit what the end game is. I mean, we all want to see the properties free and clear, but realistically, what are the percentages?
All right, Randy, here's the end game. To get a house free and clear, I'm going to say that's a pipe dream, but it happens, okay? The ability to walk into the bank and say to the president of the bank, you have dirty diapers. Do you want to litigate or do you want to negotiate? And they always would rather negotiate. And then it's a question of how much money they will take based on today's value. So if a home had a mortgage of $400,000 and it's worth $200,000 today, banks are negotiating between 30 and 60% of today's value. Now, can the individual homeowner negotiate? No. No. Because then the bank says, well, why don't you pay me in the first place? But through a program we worked out, we have investors that will buy that note, take a fair profit, keep the people in the house, and give them an opportunity to refinance under FHA guidelines under 4155 2 years later. And everybody wins. And the homeowner has his house at less than today's value. Well,
yes.
Why would someone allow a bank to take money when they don't own it? And then issue a 1099 for debt that they don't have coming. That's a Ponzi scheme. If the bank can prove through a quiet title action that they are the real holder in due course, then you can negotiate with them. But these people are stealing. I'm done.
Yeah, well, I do have the other question that came in. I'm not sure if this one you know anything about. I don't see why it would be any kind of difference, but we've got an investor in Miami who wants to know if a judge will honor a securitization in a Miami court, even if there is, I guess, a retirement to act in foreclosure or a retirement act in foreclosure cases that they may not know about.
Well, here's the question, but is that right? Here's the answer to that. Here's the answer to that. When you are in foreclosure and your attorney is representing you or you're representing yourself, you are in what we call a court of equity, or the judge is ruling on tort law. And that's the amount of the debt. Do you owe the debt? Do you not owe the debt? Is it fair? Blah, blah, blah. A quiet title action is contract law. Contract law. It's not a question of money. The judge is not ruling against an attorney who just wrote him a check the night before for $20,000 for his re-election campaign. It's contract law. And the securitization report, with admissible evidence, when presented properly, and the pleading is presented properly, right attorney understands it, and it lets the judge know that his decision will automatically be appealed. He doesn't want to go to appeals court. So he will make a ruling on contract law. I hope that answers that question.